Yes, Miss Ellis.
Thank you, Lordship. I might deal with just a couple of points that your Lordship's raised with me before lunch. And the first was that was raised in respect of the wording of 3.9, not specifying that it's a sanction in respect of the rule, it's any sanction.
Sorry, say that again.
That 3.9 doesn't expressly refer to the sanction being imposed by the rule, and it actually uses the words any sanction. It was pointed out by Lordship. I knew I had an answer to that point, and it's in Matthews. And the answer is that 3.8 and 3.9 should be read together. So when you read 3.8, it says, it's page 125 of the White Book.
So where in Matthew does it give you that answer?
So in Matthews, it's at paragraph 15.
15?
Yes. And obviously, again, that's relating to the Trinidadian rules, which I accept are slightly different, but again, I say the principle applies. It's the paragraph starting secondly, and where he says, this is aiming at rules which themselves impose or specify the consequences of a failure to comply.
With great respect to Lord Dyson, why is that obviously right? I mean, I know it's in there.
Well, absolutely, it's not binding on you, but I would suggest that that is the answer when you look at our rules. So if we look at 3.8, 125 of the White Book, 3.81, where a party has failed to comply with a rule, practice, direction or court order, any sanction for failure to comply imposed by the rule, practice, direction or order has effect unless the party in default applies for and obtains relief from sanction. Rule 3.9 applies.
Well, just to be accurate, the brackets after that don't say quite what you said. What there are is a signpost to tell you that there is a Rule 3.9. Absolutely,
yes. But my submission would be that reading that section with 3.9, the definition of sanction should be the same across both of them. Because I do think that there is sometimes a tendency to refer to sanctions merely as adverse consequences rather than as sanction as per a term of art that is defined within the rules. So I would say that 3.8 defines it, 3.9 sets out the situations in which relief can be granted in respect of it. The other part of the rules that does tie in with that and is mentioned in some of the cases as we're there is actually 310. So obviously a lot of notes relating to 3.9 and 3.10. So on 142, general power of the court to rectify matters where there's been an error of procedure. Now this rule is referred to in Cunico. The judge puts some weight on the fact that in order for this rule to have meaning, where there is not an express or implied sanction for requiring permission to do something such as filing a defence, a late defence is rendered valid essentially by this rule.
Can I put you a reason while we're on Rule 3 why your point about the drafting of Rule 3.6 may not be quite as good a point as it might look at first blush? The reason is very briefly because 3.6 operates to define as applicable the relief from sanction doctrine because 3.6 covers cases which are not sanctions at all.
Yes, and I'd agree, and that's why I say if they want to import it into something that's not a sanctions case, they would have expressly done it. And obviously my submission is we're in that territory.
Well, that depends on you being right that it's
absolutely
not a sanction.
The final point on this issue of whether it needs to be an automatic sanction under the rule I'd also like to take your lordships to Denton at paragraph 44. Tab 1, page 17. And the bit is the second part of that paragraph. The court must have regard to the realities of litigation in making orders in the first place. Judges should also have in mind, when making directions, where the rules provide for automatic sanctions in the case of default. Likewise, the parties should be aware of those consequences when they are agreeing directions. Unless orders should be reserved for situations in which they are truly required, these are usually so as to enable litigation to proceed efficiently and at proportionate cost. Stuart Simon, his article, actually points to that paragraph as well, and in support of the fact that sanctions should be automatically applied under the rule, and he says that Lord Dyson, by pointing out those two categories of case, automatic under the rule and unless orders, that's what they had in mind when they were deciding Denton. I can tell your lordship is smiling at me on that point. I absolutely don't demur from the fact that the Denton approach to case management, a more robust approach to case management, absolutely pervades the CPR post-Denton. But the question is whether the test itself needs to be imported into 13.3, or whether that approach plus the overriding objective does that job.
I mean, this is nearly 10 years ago. Amazing.
I know. There's just, you have to, I don't have many more submissions, but there are another couple of cases that I just want to take the court to. For example, the case of Mid-East Sales is at tab 16. This is another Court of Appeal decision.
Looks like Mr. Justice Burton.
Oh, sorry, yes. Yes, sorry, this is High Court. And what I'd like to look at in here is paragraph 88. It's at page 362. And again, I say that he applies the test here that he is right. He says, it seems clear to me that although applications under 13.3 do fall to be considered by reference to the new approach, and what he's referring to there is the Denton approach, a more robust approach to case management.
This looks like it's pre-Denton.
I think it's post-Mitchell, pre-Denton.
Yeah.
So most of the cases that we're dealing with are either decided in that middle period or just after Denton. And he says, I differ from Miss Justice Silver, a somewhat different approach. Now, that was a case of Samara. I can take the court to it if they want, but I'm not sure it's that relevant. But really what I want to rely on in here is that he makes a distinction between a sanction set out by the rule itself for breach may be said to be pre-estimated as the appropriate course, absent good reason, but a sanction imposed pursuant to 3.9, for example, if your lordship is correct and there are sanctions that aren't within the definition of the 3.8, but are still sanctions within the 3.9.
So which paragraph are you looking at?
Sorry, 88.
Oh, 88, I'm so sorry.
It's probably
Tracked
me.
it by your side. No, I think you did say 88. I'm sorry. Yeah.
362. A sanction imposed pursuant to 3.9 or application by reference to 3.9 and 13.3 may allow different or wider considerations to be taken into account or more than trivial delays to be addressed. And he sets out some points there, including sort of the importance of the claim. Now, what I say he's done there is he's applied the overriding objective. He's said that 3.9 is relevant, the new approach is relevant, but all the circumstances and all the factors are relevant And that's especially important where it's not an automatic sanction applied under the rule. Your Lordship also made a point about how Denton was and is very important in ushering in the new approach to case management and how it helps courts allocate resources fairly, etc. And the question was, don't we need Denton to do that? I don't think I dealt with that fully. My answer to that is, it is expressly set out in the overriding objective that compliance with rules, court orders is important, proportionality is important, and that's at page 11 and 12 of the White Book. And expressly refers to allotting it an appropriate share of the court's resources. So in my submission, if there's no logical reason to apply Denton, if the logic is there's no sanction within the definition of 3.8 and 3.9, the court doesn't need to apply Denton in order to facilitate robust case management because it is covered by the overriding objective. There's one other case that I would like to take your Lordships to and your Ladyship, and it's the case of Ishinryu. It's at tab 11, page 222. This is a case that is referred to in the article by Stuart Syme on this issue. This was a case also looking at what's the test when applying out of time for permission to appeal. Court of Appeal case decided after Mitchell and Denton. And I'd like to go first to paragraph 26. Interestingly, again, because we don't have the reports, it's difficult to tell, but this case refers to Matthews. So it's one of the few domestic Court of Appeal cases that does refer to Matthews. And starting at 26, after there's discussion of Matthews at 25, the Court of Appeal recorded the defendant's submissions from Mr. Nicola, who submitted that since 5242 imposes no sanction for a failure to file a notice of appeal within the prescribed time, there's no need to make an application under Rule 3.9. An application for an extension of time is not and should not be treated as if it were an application for relief from sanction. I have considerable sympathy with that submission, which seems to me to reflect the natural meaning of the words used in 3.8 and 3.9. In my view, the reasoning of the Privy Council, which underpins its constructions of the rules of Trinidad and Tobago, applies with equal cogency to 3.8 and 3.9, which on that view should be understood as limited in their application to sanctions imposed prospectively by a rule, practice, direction or order of the court. If that was so, applications for extensions of time for permission to appeal would not generally be subject to the full rigour of the principles applying to applications for relief from sanctions. So, in the absence of any authority on the point, I say the Court of Appeal is quite tempted by the argument that Matthews is right and that because no sanction is provided, the relief from sanctions test shouldn't apply. What then happens is the court looks at the line of authority that got the parties there, and it starts with the case of Sayers and Clark Walker at paragraph 27, which is the case we looked at it's not in the bundles, but we looked at briefly in the Stuart Syme article, which is credited with starting the implied sanctions doctrine. The court then analyses those authorities. At paragraph 28 of Sayers and Clark Walker, the court says the decision was not referred to in Matthews, but it's possible this passage was the source of the implied sanctions doctrine. That was disapproved by the Privy Council in that case. Whether or not that is so, however, the decision has been treated in this country as authority for the proposition that a person who's out of time for filing a notice of appeal is subject to an implied sanction, and that an application for an extension of time is regarded as analogous to an application under 3.9 for relief. Then turning to paragraph 35 on page 232, Mr. Naffler, who I fear may be in somewhat of a similar position to myself, was attempting to persuade us the view that he took, the view which the court took of the authorities in a previous case that was decided by this court was wrong. He submitted that Sayers and Clark Walker had been misunderstood and applied, dicta in the cases to which I referred were not binding, and that Barho and Mirza was decided per incuriam because the court in that case had overlooked the sentence in parentheses. Then, accordingly, he submitted we were free to hold that the applications for extensions of time to file a notice of appeal should not be approached in the same way as applications for relief from sanction. The court went on again, I confess to finding that submission attractive, but having re-examined the authorities, I'm not persuaded that course is open to us. As the authorities demonstrate for the past 12 years, it's been consistently understood that Sayers, this court deliberately equated applications for extensions of time for filing a notice of appeal with applications for relief from sanctions, because in its view, the implied sanction of the loss of the right to pursue an appeal meant the two were analogous. Whatever one may think of the doctrine of implied sanctions, therefore, particularly in light of the views expressed by the Privy Council in Matthews, I think that the approach to be taken, importantly I say, taken to applications of the kind now under consideration, i.e. permission to appeal, is now too well established to be overturned. So what I say in that case is it says, yes, you're right on an analysis of there's no sanction, it probably shouldn't apply, but I'm sorry, it's been going on for 12 years, it's too entrenched to overturn that now. And that's what I say, this court has an opportunity at this point, because there is no cohesive body of case law like there was in the Sayers case, and I say no binding Court of Appeal cases on this issue. This court has the opportunity to, by design rather than by default, set out what the test is. So I would suggest that Hysage is a useful case for looking at why it is not necessary for the relief from sanctions test to apply where there isn't a sanction.
I believe Hysage was referred to in Gentry. I'm anyway very familiar with Hysage, so I'm just looking it up to see if I've referred to it. I don't think we've got the report in Gentry yet, have we?
It's not cited. I don't think it was cited, not in the version of the report that I've got.
No, nor mine.
So I say Hysage is an important decision for the respondent here. It is different for three main reasons, though. Firstly, what the court was grappling in that case with was this issue of implied sanctions, where there was a mandatory time limit for filing for permission to appeal, after which permission was required. And at the outset of my submissions, that's a key point for the respondent. There isn't that in the case of a defence. Secondly...
What do you mean by after that permission is required? I mean, there's a mandatory time limit for permission to appeal.
Yes.
You can and you can seek an extension.
Yes. So which would be, as per this, an out-of-time application for extension
Yes.
of that time. Yes, that's what I mean
That's
by
what you
seeking
mean.
permission.
Thank you.
Sorry.
That's all right.
So whilst it's true that 54.42, which is the provision in HISAJ, might impose an implied sanction, actually the same isn't even true of 15.4. So if HISAJ is an extension of relief from sanctions beyond express sanctions, what in 15.4 you have an extra step even beyond that. Secondly, goes without saying really, but 13.3 has its own test for setting aside default judgment, whereas there was no test in the rules under 54.42. And then thirdly, as I've already said, the court felt obligated to endorse a line of authority in that case. And I say in this case there isn't such a line of authority. One other quite discrete point I'd like to make is that the White Book in the note to 13.1 talks about how if default judgment is entered pursuant to an unless order, then relief from sanctions does apply, because Part 13 doesn't apply. That's at page 441.
What's the logic in that?
The logic is because an unless order is an automatic sanction provided under the rule or order.
So you read automatic into the rule, really?
I say that automatic is implied by the reading of 3.8 and 3.9 together, and supported by Lord Dyson's comments in Denton.
But I mean, HISAJ says that that's not right. HISAJ says expressly that an automatic is not to be read in. You can have implied sanctions.
So on that point, if you didn't make it clear, because I emphasise...
It's obiter, isn't it?
No, but it is confined to that particular provision, 54.42.
Well, I mean, yeah, but it's... maybe it is, but of course it is confined to that particular provision, but it would be totally illogical to have different parts of the civil procedure rules, surely, where you have different rules depending on whether it's Rule 3.2 or 4.6 or 38.1. I mean, either where there is an implied sanction, in other words, where something else has to happen, it's a sanction from which you need relief, and Denton applies, or Denton is a very confined and limited to automatic sanctions, and the word automatic ought to be read into the rule. I mean, that's a perfectly sustainable proposition based on Lord Dyson. But, I mean, it's interesting, Lord Dyson gave that judgment, but I mean, I can give evidence here. During the whole Denton process, that case was never mentioned.
Yeah, it's not cited anywhere, and it was only 3 years before.
But I know, and Denton was only 3 years afterwards, and don't imagine that the Denton process was just a sort of case on a Friday afternoon.
Oh no.
And then we all went off, read the judgment over the weekend and said, there you are. It wasn't like that at all. It was a very seriously considered case, and we had, I think, 3 days in court, in this court.
Well, the list of counsel in it as well.
And the list of counsel is long as your arm.
Yeah, absolutely.
So it was a really seriously argued case. And so, I mean, I'm not swearing to you on a stack of Bibles that Matthews was not cited because I don't remember. But I certainly don't remember Lord Dyson saying, what about, I've just said.
Well, yes. I mean, I don't even really know whether I can make submissions on this because I say you can give evidence on it, but I wonder whether the reason is because all of the sanctions in that case were express sanctions, and what the court was concerned with...
In Matthews?
No, in Denton.
No, in Denton.
Oh, in Denton, yeah.
Yeah.
Which is true.
And what the court was concerned with was setting out the new approach.
Yeah, yeah. Well, yes, we're going to have to wrestle with this, aren't we? I mean, it's not straightforward, but I mean, I think everybody would agree, even you, I think, Miss Ayres, that a clear answer is needed.
Yeah, which supports my position that there's not a consistent body of case law that you should be
No,
obligated
I mean,
to
I
follow.
described it this morning as a parallel universe, and you know, I must say, as I've looked at all these authorities, I think I sort of thought that Denton had put this all to bed, and it just hasn't.
I think it very much has in the case of express sanctions. I think there's a halfway house in respect of implied sanctions, because out-of-time applications to extend time are generally done with respect to Denton. But I still say what you have here is something different from even those two categories.
Well, I mean, your bull point is that a 13.3 is a coherent regime.
Yeah. And yes, it's discretionary. It says may, but it should be the overriding objective rather than something.
We completely get that. And I mean, if we call it a coherent regime and something that doesn't need overlaying with something as complex as Denton, I get it.
Just picking up on something you just said, Rosa, if you don't mind, I respectfully agree with you. I just want to make sure I've understood it. I think I agree with you. That there are at least three different categories of thing around here. There are situations in which a provision, whether it's an order or a rule, expressly provides for a sanction for its breach.
Yeah.
And everyone agrees, in those circumstances, 3.9 applies. Then there are situations in which the relevant rule, the coherent body of rules as a whole, provides for no sanction at all expressly, and one gets into a discussion about whether there are implied sanctions. And in the end of the day, like implying terms, that's always going to depend a little bit on the construction of the rules as a whole and all the rest of it. And then if it is an implied sanction, what regime applies to it. And the thing about implied sanctions read that way is that they do seem to fall within the idea that they're automatically in the rule because they're implied in the rule. So 3.9 catches them.
Yeah, by use of the word must.
Then there is another different class of sanctioning, or thing, let's say, and using a word neutral, because I get your submission, you say they're not sanctions. There's another different class of thing, which is what I'm going to call sanctions, because I can't think of a better word at the moment, which are in the rules, which are consequences on failure to follow procedure, but are expressly in the rules. They're just not in the specific rule that you didn't follow, and that's like default judgment, and it's like 39 not turning up to trial, and there are probably other ones. And those three categories, and they are distinct from each other. And can I just put this to you? What I'm bothered about, speaking as someone who spends every Friday of the month chairing the Civil Procedure Rules Committee, is it seems to matter whether 13.3 is in 13 or was in 12 or in 15, because it seems to make a difference whether Rule 13.3 is to be regarded as part of Rule 15, which says you're supposed to file a defence, and because it's not in Rule 15, it's in its own rule, it's not part of the rule that says you have to file a defence, to apply this doctrine, which at the moment I find a difficult distinction to see. It seems to be dependent on a complete happenstance of which bit of the CPR the putative sanction provision is in.
I think I've struggled to find other situations where and I'm going to use the word sanction, colloquial parlance.
Small s sanction.
Exactly. Is imposed by its own codified process as per Part 12, other than for judgments. So it may be that...
probably. Well, there's the turning up one, I'm sure there's a more proper name for it, but turning up for trial and default judgments. Those are two.
And the difference with the turning up one is that the test under the 39.3 is more stringent than even Denton.
Yeah.
So it doesn't really matter with that one whether you've got to pass the pretty significant hurdles first anyway. What's different about default judgment is that whether it's an unfettered discretion or Denton might make a difference. The point I was just going to make on the note at page 441 about relief from sanctions being applicable to default judgment entered pursuant to an unless order is it's more of a question I'm posing, I guess, but it's more, if that's the case and the Denton test applies for relief from sanctions to get around the unless order, arguably that would be an easier test to satisfy than 13.3 plus Denton. And it seems to me that an important consideration when you're thinking about part 12 and 13 is that they're part of the originating process for claims. So my submission is it makes sense that there is an ever so slightly more or a completely unfettered discretion when you're already at that stage of very early stage of proceedings. Whereas once you're in proceedings and you violate the court's order, it makes sense for the court to apply the relief from sanctions test on an arguably more stringent basis.
I mean, I would have thought that defence was preeminently a critical stage of any case.
And I would completely agree with your lordship, but the point is not that it's not important, it's that for any number of reasons there might have been an issue bringing it to the defendant's attention. There might have been any sorts of things happening before the defendant is engaged in the court process that might mean that an unfettered discretion, that you can bring anything into account in any way.
I said in Gentry that you take account of that. The delay is only once you know.
Absolutely, and that is obviously a way of dealing with it. But again, it goes back to the point of, I think the only point I'm making is that because we're dealing with origination process of claims still, my submission is that it makes sense to have an entirely unfettered discretion when you're at that stage in proceedings, rather than when the defendant is under the court's jurisdiction and has not complied with an express rule or order from the court. And that was just the note at the bottom of 441 in the white book. So I think the final point I want to make on the substantive submissions, before dealing with actually what Master Thornett decided, is your lordship asked me a question about the status of Gentry in terms of precedent, where a point...
And you've given us Kadim.
Yeah. Tentatively, I say that it backs up my argument that where a point wasn't argued, although technically it forms part of the ratio. You've got to be a
bit tentative about that submission, because Kadim actually says that if it has been explained, I mean, even the holding in the head note says, if scrutiny of the judgment indicated the court had nevertheless considered the point rather than assuming it to be correct, it is binding.
Absolutely, and that's why I said tentative.
Yeah, that's your tentativeness.
Yeah, but...
I mean, it was Kadim I was thinking of when I said it's not quite right to say.
I think it was what I was thinking.
It's sort of, it wasn't argued and therefore it's nothing.
And I absolutely don't want to say it's not nothing. I'm not saying that. It's just that the reason for that is because of a situation where, for example, all counsel are agreed on a point and it's not argued.
Yes, I think in that situation you're absolutely right. But, I mean, where I slightly balk is the way Mr. Justice Baker dealt with it. By just saying all this is, all these cases got nothing to do with anything. I think we might not agree with that precisely.
Well, I would then respectfully submit that your lordships and your ladyship refer to PXC for a more reasoned analysis of why, if you agree with me, that's the case.
Yes, I mean, Mr. Dice, at least has the good grace to try and explain why he thinks he's not bound, and that's, as you say, a perfectly viable point of view.
Because also what you have on this issue of precedent is...
But we're bound too.
Well, absolutely. That's the point
not just
I was
him.
just going to address. But
Yeah.
if there are two conflicting decisions...
Then we can choose.
Yes, which I say that Piemonte and Gentry are at odds, because one says 13.3 an overriding objective and the other says 13.3
Yeah, well, we won't go around that track again.
Yeah.
Yeah.
But if there are odds, then Piemonte should be preferred. So if I might just summarise briefly, the respondent's position that there's no binding authority on the issue of whether exclusively the Denton test should be applied in addition to 13.3, and that if liberated from authority, the court should, in one sense, take heed of what is said in Hysage and find that there is no sanction that we are dealing with here. That is supported by Matthews. It's also supported by the words of the CPR themselves. Where filing a late defence doesn't attract a sanction, in my submission, the latest step of imposing default judgment is also not a sanction within the meaning of 3.8 and 3.9 read together. If there is no sanction, then there is no reason to import the Denton test into 13.3. It's by doing so, it's apt to bring about confusion, for example, in the treatment of merits, which are front and centre stage 1, and under the appellant's analysis, almost not relevant to Denton. And the reason for that, it being the overriding objective rather than Denton, in part is informed by the fact that we're within the originating process for claims. And Part 12 is an anomaly within the CTR in that respect. I said that that was the final authority. I would just like the court to take the court's one more, and it's the case of Hockley.
This has been a fertile ground.
And this isn't... yeah.
Hockley.
tab 15.
Tab 15.
It is another High Court case, and it's from just, thank you, after Denton. And all I want to do with
Is Mr. Richardson again? Is Judge Richardson against on your side of the line as well?
He's walking a tightrope down the middle that no one else has really decided. And
He's got his own tightrope.
No, the reason I refer to Hockley is to highlight this issue of the potential confusion of importing one test into another. So I rely on the treatment of merits as one ground for that, and Hockley as the other. And I'd like to look at...
is this post-Denton?
It's just post-Denton, yes. Denton was June, July, I think. This is September. Where paragraph 34 is what I'd like to have a look at. It's on page 309. Now, just before we look at that, what the judge in this case decided was that reference to some other good reason in 13.3.1b was the same, quotes unquote, good reason as the second limb of Denton, which in my submission is obviously wrong, because 13.3.1b is good reason for defending the claim, and second limb of Denton is good reason for the default. So they are two different things. Whether there is overlap, I'm sure there is, but 34, he says, he's talking about the good reason and the good reason. He says the difference in language is purely, this is halfway down, is purely semantic and not of importance. The jurisprudence underpinning both rules is the same. I don't think that's true. I cannot envisage a case where relief from sanction would be permitted, but there are no good reasons for setting aside the judgment. The reverse is also true. How could it be said there are good reasons for setting aside the judgment, but they would not meet the criteria for relief from sanction? Although there may well be cases that the good reason is the same as the good reason, I think it just highlights the fact that, again, it's apt to confuse rather than clarify matters, when if it's simply an unfettered discretion, as applied by Judge Davies.
I love paragraph 35. I mean, I think that's absolutely wonderful, and I'm sure we can all agree on that. We should just...
I think my submission would be that Mitchell and Denton have profound importance generally to the CPR. They absolutely do, and what he means is the approach. The more robust case management new approach absolutely has critical importance for example, the promptness requirement in 13.3 can quite clearly be analysed by reference to those Denton factors. But it's my position that it is not just the Denton test. It's the overriding objective.
Yeah, we've got that.
Thank you. So finally then, after all of that, my final submission is that it makes no difference in this case.
Judge was right.
The judge was right. And in fact, it is a conclusion that several of the cases that we have looked at, including PXC, Judge Davies says that the analysis would be the same either way, because actually what you're doing here is saying, is the punishment fit for the crime? Is it a proportionate outcome?
But yours was quite a big crime. I mean, it's not as if there were no solicitors involved. This was a little person. This is an insurance people who deal with these cases all day long, who'd read Denton.
No, absolutely.
And knew that there was zero tolerance nowadays.
And there's no, it explains entirely why I didn't seek to justify to a great extent.
You don't try and justify it, no. But what do you say? You say on your even on any analysis, even if Denton is right, you say, A, the master took it into account.
Yeah.
B, in this case, you've got a seemingly good defence, or something that is very arguable, if not good.
I would go further than that.
Yes, you've got a properly arguable defence. I mean, you don't need. It's not bound to succeed. No. Obviously, we wouldn't be here if it were bound. Well, we would perhaps, but anyway. And you say it's very important under 13.3 anyway, and Denton can't be used to sweep all that away when on the 13.3 tests you get through very clearly.
Yes, exactly. And the way that the appellants have formulated what they say the test should be, 13.3 Denton, it does exactly that. It sweeps away the success that you have sailed through the real prospects test, and then you would fail at the second hurdle. And in my submission, that can't be what was intended by...
So do you say, I mean, so you say I was wrong, and I mean, I can see this argument quite clearly. You say I was wrong in Gentry to say go through 13.3, then apply Denton.
Yeah.
But even if Denton is applicable, the exercise, do you say, has to be all done at the same time? It's all part of the discretion.
So the only thing that's mandatory is passing that initial hurdle of having real prospects or some other good reason. Then it's all part of the discretion, but you do weigh into the balance how good is the reason, how strong are the prospects.
Okay.
And I say that's what Master Thornett actually did in this case, having seen my skeleton argument on the issue of vicarious liability. I was chuckling at how your Lordship and your Ladyship started by saying that the hearing sounded quite fiery at the beginning, and certainly that's what it felt like. And what the Master was quizzing me on were what's the reason for the delay. He was quite clearly...
You've never given a reason for the delay.
I did.
Well, you tried.
The master didn't like them.
No.
No.
But I did, and that is all in...
What were they? Just remind me.
So there's an insurance issue, an insurance coverage issue,
Oh, yes, yes.
and there were issues obtaining instructions from Mr. Donovan, who is the sole trader, who is the organisation.
Who was in Thailand?
Who's in Thailand.
Well, I couldn't work that out, whether when he was actually in Thailand, because this was all in 2019. 2020, but he must have been in Thailand before COVID.
He lives in Thailand.
He lives in
Yeah, yeah,
Oh, right, okay.
yeah,
So he was in, I see, so he's in Thailand for the duration.
yeah.
I see. And so how is he served?
Well, that's... I'm not sure, it was before Kios came on board. On record, I'm not speaking instructions on it.
It was sorted, wasn't it, between the claimant solicitors raised a query as to the correct address of service.
I think there was, if I can help, an order for alternative service, and he was served by email.
Thank you, my lady.
But I mean, he was full, even though he was in Thailand, I mean, I looked for this, there's no case that he didn't know about the proceedings.
No, my instructions were that it'd been quite difficult to contact him. And then there was a situation where he's in Thailand, we're having difficulties taking instructions, and actually the majority of the claim isn't covered by the insurer, who was also providing instructions to cover their interests in the claim. But there's a situation where you're trying to seek instructions from both. The stays were so to investigate the insurance position.
I see. Insurance covers what? Only part of the period?
Yes, I believe it was about 70% uninsured. 28% insured, 72%.
28%.
Yeah. So that was what was...
But that's in time terms. That's in the period of the abuse.
I think my instructing solicitor will take instructions on it. That's usually how it works.
Yeah, that's what
I think that's right.
Yeah.
Okay.
So that was what was...
So the reason for delay was you were sorting out coverage issues. I mean, that's not really a reason at all.
No, and I haven't cross-applied to say that the master was wrong, to say that there was no good reason. I tried my best.
Right, you don't say that.
No, there were reasons, which it actually is quite an interesting point of how it brings into focus the fact that the overriding objective, you take a slightly broader view of this, rather than asking the question, is there a good reason? Because there were reasons, they weren't great, and I don't seek to demur from that, but there were reasons. But the master obviously wasn't impressed by them.
And the essence of your defence, as I understand it, is independent contractor. Is that too
Absolutely.
simplistic?
Yes, and I would go so far as to say almost it's a cast iron defence. It was the reason those submissions were made like that. It was in the wake of the Barclays and various claimants case,
Which was all about the independent contractor.
and it crystallised the law on saying there was a lot of, is it the 5 incidents? How do you say how someone is an independent contractor? And we say in this case, it is obvious that the alleged abuser in this case.
What's the relationship between the first and second defendant?
No relationship.
Right, and what were they then? I mean, Mr. Donovan is what?
So Mr. Donovan is the IKA, the Ishinryu Karate Association. He is it. They have no employees. They have no...
Right, and why, I mean, just in a nutshell, what I sort of didn't really understand was the first defendant runs the gym or the karate location, does it?
I think they're the English Karate Federation. I may be speaking out of turn here, my learned friend might be better able to assist, but they're the English Karate Federation, and I think they investigated the complaint against the alleged abuser.
Yes, but we need to know that the alleged abusers relationship with the defendants. So was he a member of the first defendant?
So my understanding that he has no relationship with.
Because I read the pleading, the lengthy pleading, which, I mean, you know, for the avoidance of doubt, makes this a very serious case, whatever liability.
Yeah.
You know, it's a very serious case and very pleaded in some detail. But what I couldn't work out was what I was actually looking for, but I then got engrossed in all the detail. But is what these two defendants were. I understand it said they had a duty to protect the claimant. I get all that, but I still don't see quite. Maybe I didn't look closely enough to see.
Well, no, that's the point. I mean, I can only speak in respect of the second defendant. So the second defendant is Mr. Donovan, and he developed a style of karate.
Right.
The abuser taught the claimant that style of karate. And that's the submission that was made before Master Thornett, who responds to my learned friend sat behind me.
Right. So can we just bottom out the first defendant? I mean, what is the first defendant?
It might
Jim?
have.
Is it? You don't know.
As I understand it, it's the Karate Federation, the National Karate Federation.
I know, but what's it got to do with this person?
Well, we would say, as we would say with the second defendant, they are both, in inverted commas, they both employed this man. He was the national coach in karate.
They employed him.
Employed in inverted commas because there's an issue with that.
Or akin to employment.
Akin to employment. All of those arguments that.
So the first defendant is the National Karate Association, and that has been properly served, and the action is proceeding.
Yes, that's exactly right. Can I just correct one point? It may not make any difference. Mr. Donovan is also on the board of the first defendant. Where that takes us in respect of vicarious liability against him is a moot point, but we certainly don't accept that prospects are as they will carry.
Okay. Yes. Okay.
Just to expand on that, I'm told that he was on the board at the time of the claimant's complaint. He was both the second defendant's owner and the first defendant's former president. So he did have links with the first defendant.
Just for your, I mean, my arguments on this were in my skeleton argument for the appeal below, for the hearing below, which is in the bundle.
Yes. What? Just give me the reference to that.
Page 89 onwards.
Okay.
And it all relies on Barclays.
Yes, that's all the defence point.
Yes. So I say it's obvious that the master was impressed with that defence being compelling, partly because he didn't really ask me anything about it at all. It was simply, I've read your skeleton.
But I mean, you don't say you can't fail to set aside a default judgment even when you've got a compelling defence.
No. It can happen, but I say within the ambit of discretion that Master Thornett was applying, this decision was reasonable. In the early exchanges with my learned friend, he made a point that I was already going to make. It's somewhat of an odd appeal where the appellant's saying he didn't apply Denton, but yet Denton is littered throughout the transcript and the judgment. And I would say that, as your lordship pointed out, you have to take the transcript and the extemporary judgment together to actually determine what the judge decided. In a time-pressured extemporary judgment, the fact that he didn't go through the Denton stages, if that's what you find is required, as I say, is fine when you look at the rest of the transcript.
But he does use that telling word, it permeates, doesn't he?
He does. And it does. And in fact, actually, I say Master Thornett applied completely the correct analysis. because he took Denton into account. But he didn't just take Denton into account. So I actually say it's the correct analysis to not go through it. But even if it is, he took into account all the relevant factors that he should have done. Now, my learned friend made points that he didn't, such as the fact that the claim concerned an important subject matter to the claimant, sexual abuse, and that there's another defendant, for example, is what my learned friend said. But my counter to that would be that those cut both ways. In fact, the master was referred to the case of Birss in my skeleton argument for the underlying hearing, which says where there is an important point to be determined, it's all the more important to set aside default judgment because it is important that the court tries this on its merits. So it's a point that goes both ways. Equally, the multiple defendant point also goes both ways because I think it's Hussein, but I'd have to check it, where there are multiple defendants and a default judgment doesn't equal the end of proceedings, that can actually be viewed as a reason for setting it aside. So there may always be points that aren't referred to expressly within a judgment, but I say those ones cut both ways. It's not for this court to see which way they would cut. But quite clearly in the master's exchanges with me, he was head on addressing this issue of why the default, why so late. And for several pages of the transcript he's doing that. He also says, page 24, this is his, in the transcript, page 24 of the bundle. 5 paragraphs down, he says, I agree with you that if the delay is so heinous and so without explanation, it can eclipse prospects even where merits are seemingly compelling. So he obviously recognises that there is a circumstance where the delay can be so bad and compelling merits and judgment shouldn't be set aside, but he clearly didn't think that this was such a case. And actually, in the exchange above that paragraph, you can see his confusion almost of the submission that was being made about the relevance of Prince Abdulaziz, the Supreme Court case that we've looked at. Because he's saying, my learned friend says, on the merits, we say it's only of limited relevance. And I say, quite rightly, Master Thornett says, I don't really get the relevance of that case here. When one considers merits in the context of breach and sanctions, that's not compatible with 13.3. And the court should have regards to prospect of successful defence. So it again just highlights the fact that if you don't need to import the test, then an unfettered discretion is preferable. It's quite clear from the authorities that the issue of fact and nature of the delay versus merits is an entirely fact-dependent exercise. So there's no hard and fast rule about how long is too long. But the master clearly knew that there were situations where the delay would be too long, that it would be appropriate to set aside even a very good defence. And what he says on page 25 at the top is when there's an exchange with my learned friend about the substantive defence of vicarious liability. You can't say that because of the particular style of karate there is a relationship of vicarious liability. And that was the nub of our argument, that there is obviously no vicarious liability here. And he was impressed by prospects of success, where, turning to page 27, at the bottom of 27, you've seen this exchange already. It says, it's clear that the case on vicarious liability will be both arguable and sophisticated. I've been referred to authority by Ms. Ayres, read the detailed skeleton argument. prospects. The bottom of paragraph 4, the factual matrix and in turn application of legal principles that's proposed passes the 1331 threshold. And then the bottom of the next paragraph, which again I say is a completely accurate statement of how to conduct this test, ultimately I find does not eclipse the merits of the proposed second defendant's defence, even though he says there's no convincing explanation for the delay. He also says that limitation provides a separate ground for there being real prospects. And he's clearly unimpressed at the top of page 29 with my replies to justifying the delay. I would also counter with my learned friend made submissions of what the master didn't take into account. I would suggest that there are, it's difficult, but I would say that there are things that he would have had in mind that aren't expressly referred to in the judgment, such as the nature of the claim, it being important to resolve it on the facts, the multiple defendants. And then what he does, which I say again is textbook treatment for where my explanations were not accepted. He puts very tight time frame on filing the defence, and he penalises the respondent in costs. So what he actually says is, on page 29, in the big paragraph there, the end of the third line down says success for the second defendant on this application, that is, as an overall procedural observation rather than under 13.1, has to be measured by a very fine margin when it comes to deciding what consequential directions should be made. So he recognised that there was no good reason for the delay. He found the defence compelling, and the way that he dealt with it was to grant discretionary setting aside and penalise us in costs and with a tight timetable for filing the defence. I think it was either a week or it was 2 weeks. I remember doing it in very short order anyway.
It was adventurous coming to that application without a defence.
And that was another thing, he took that into the mix, and that's another thing to take on board in respect of the overriding objective. And he did, and he was not impressed with it, and I got his fire for that, which I was completely right.
You got a blast of cold air.
I absolutely did. And then I don't need to take you to it, but what is also in the bundle is G&G and phonographic performance about the generous ambit within which reasonable disagreement is possible, even if your lordships and your ladyship were to disagree with the result. There's nothing wrong about what the conclusion that the master came to. And ultimately that's a decision of, well, would Denton or the overriding objective have made any difference? I think the answer in this case is probably not, but in some cases it might. So even if he applied the wrong test and he should have gone 13.3, and then Denton, we say the outcome would have been the same. And I think, unless there's any other questions.
Thank you very much.
Thank you.
Yes, Mr.
I'll be brief. Can I first of all deal with the issue that Ellen Friend has been dealing with for most of the time, and then just deal with the question at the end of the submission that the master got it right. We would say that there cannot be any good reason, either as a matter of law or logic, for applying a different test to applications to set aside a default judgment, or indeed applications to set aside judgment when a party doesn't attend trial under 39.3 from all the other applications that to set aside that are made. Indeed, it would be bizarre if a breach of that seriousness the test was less stringent than it would be in relation to other breaches. And we've not referred to it, but can I just take your lordships to a comment of Mr. Justice Coulson, as he then was in Redbourne? Just one comment at paragraph 17 on page 98 of the authorities. He says this at paragraph 17. There was some debate in the original skeleton arguments as to whether 3.9 was relevant to an application under 13.3. My view, prior to being shown in the authorities, was that 3.9 was plainly relevant to any application to set aside. After all, there's no greater sanction than judgment being entered in default of a defence, and no more important relief from sanction than being allowed to set aside that judgment so as to be able to put forward a defence. And in my submission, that's exactly right. This is a sanction. Whether it falls into any of the categories which my Lord Justice Birss listed a little while ago, it's a sanction. And the clue to that is 3.9, and your Lordship referred to that. In 3.9, the rules provide that on an application for relief from any sanction imposed for a failure to comply with any rule, practice, direction, or court order, the court will consider all the circumstances of the case so as to enable it to deal justly with the application, including those two factors which we've looked at a lot, A and B, as articulated by your Lordship, in the case of Denton, earlier in the case of Mitchell, and the process of which was explained in Gentry, which should be followed in my submission. Second point is this. I slightly hesitate to go back to Piemonte, but very briefly, if I may. My learned friend, you'll recall, picks out two paragraphs. I think it's paragraph 36 and paragraph 126. Without taking you to it again, unless your Lordship would like me to.
It's also paragraph 37 and 38.
Exactly. 37 and 38 are the important ones. 36 and 126, the court is dealing with the delay before an application is made. And in that case, the delay was really extreme. If your Lordship looked at paragraph 43 of that judgment, perhaps I could just, we haven't looked at that. Paragraph 43 is at 61. He says, as to the delay, he held that Piemonte had failed to act promptly to seek to set aside, and that such delay was a very strong factor in favour of dismissing the applications. So it's that delay he's referring to. The claim forms in the declaratory actions were served in January 12, some 17 months before the hearing before him, and for most of the time since then, Piemonte had taken a deliberate decision to ignore the proceedings. And that's the explanation. The balancing exercise to which his Lordship is referring in paragraph 36 is between, are there realistic prospects, and then taking into consideration the delay before an application is made. Next, Cunico and PXC, as it's now called. I'll deal with those very briefly. In Cunico, the conclusions on the applicability of Denton were expressly stated by Mr. Justice Andrew Baker to be obiter. Cunico, of course, didn't involve an application under CPR 13.3. It was an application to challenge jurisdiction. Mr. Justice Andrew Baker took the view that applications to set aside default judgment do not amount to applications for relief from sanctions, but he conceded that he was bound by authority. C&D, the Mr. Dias case, or rather PXC as it's now known, it was called C&D at the time. facts of that case were very stark. It was a default judgment in excess of £6 million, and it had apparently been issued against the wrong defendant, which had inexplicably failed to deal with the case after service of the proceedings. The Deputy High Court judge, no doubt conscious of the fact that an error had been made, granted the defendant's application to set aside judgment. A footnote to that case is that in that case the claimant obtained permission to appeal, but the case was compromised before the appeal was heard. Your Lordship now has Mitchell, which sets out the old wording of 3.9. If Your Lordship has that to hand, and it is helpful, there are differences between the old 3.9 and the Trinidadian rule, which Your Lordship would find in the bundle referred to by Lord Dyson on page 30. Most of those differences are pretty minor, but there is one significant one, which is that in the Trinidadian rule at page 30, it's provided at sub-rule 3 that the court may grant relief only if it is satisfied that, and then 3 preconditions are set. And then in sub-rule 4, must have regard to 4 more. Of course, in the old 3.91, there was no requirement because the wording was the court will consider all the circumstances, including, and then the checklist of 9 factors. As far as those 9 factors are concerned, if Your Lordship has paragraph 24 of the Mitchell judgment, A is the same wording.
When was the change?
Not sure. I'll find out about the Your Lordship there. B is different. C is the same, intentional. Good explanation is the same. E is extent to which party involved has complied with other rules. That's the same. F, failure to comply was caused by the party or his legal representative. That's the same, except the word attorney is used in the Trinidadian ones. G is the same. And H and I don't appear in the different Trinidadian rules. But the principal difference, as I say, is that some of those requirements are mandatory, whereas they're not in the old 3.9. So, insofar as the case is important, one might think that Lord Dyson was more justified in thinking that it is a self-contained rule with its own hurdles to overcome than perhaps is the case in relation to either the old 3.9 or the new one. Finally then, to the argument that the Master got it right, we simply don't accept that. And with respect, he didn't apply Denton. Even if it's right to argue that there was consideration of criterion 2, namely the delay, and there certainly was in the argument, and he certainly refers to that, there is no specific reference to criteria 1, seriousness, breach, but by far the more important one is that there is absolutely no reference to what is perhaps, according to paragraph 32 of Denton, of all the circumstances. Simply none at all. There isn't either in the judgment or in the legal argument, the legal submissions which preceded it. And although these factors are referred to in the claimant skeleton argument, there's no reference at all to it in the defendant's skeleton argument, in my learned friend's skeleton argument. There is no suggestion that he expressly took into account factors such as factor A in 3.9, the need for litigation to be conducted efficiently and at proportionate cost. Factor B, the need to enforce the rules. And then other matters which are important to this case, such as the inconvenience to the court and waste of resources, and most importantly in a case such as this, the impact of the delay on the claimant as a survivor of sexual abuse, and indeed, perhaps not as important, but important nonetheless, the impact on the first defendant. And there was no discussion about that whatever. So with the greatest of respect, it cannot be said that the master properly took into account that criterion from Denton. And as Denton itself says in paragraph 32, I've taken you to that already, the two factors, A and B, may not be of paramount importance. We assert they are of particular importance and should be given particular weight at the third stage when all the circumstances of the case are considered. And in those circumstances, with respect, it cannot be said that the Denton criteria were gone through properly and considered. And if he had considered all of those things, particularly the importance of enforcing the rules, perhaps, and the effect upon this claimant, then he would not have reached the decision which he did reach. My Lord, those are my submissions.
Well, thank you both, and thank you to your solicitors for an interesting and difficult argument. We'll take time to consider our judgments. We'll hand them down in the usual way. When we do, please only use them for the purposes of agreeing an order and costs, and not for any other purpose, suggesting any typographical errors, and everything else will be dealt with in writing thereafter.
Thank you, my Lord. Can I answer your Lordship's question, which you asked a few minutes ago? With effect from the 1st of April 2013. In fact, I think there's a footnote in there to that effect.
1st of April.
1st of April 2013. Civil Procedure Amendment Rules 2013.
That was my recollection. It was introduced as a significant change pursuant to the Jackson reforms.
Yes. And the other matter which, the other request that your Lordship quite rightly made was that you have a proper bundle of authorities. We will attend to that and hopefully have it with you by the end of tomorrow.
Yes, even quicker if possible, but there we are. Thank you, but certainly by the end of tomorrow. Thank you.
Court rise enabled.
Electronically.
Electronically. I like